Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and part of what we do is we help people who are dealing with debt. And this may be a debt buyer suing them, or it may be the IRS coming after them. So I like to go through every now and then some tax court decisions because it shows us what are the tax courts looking for or looking at when we're in a conflict with the IRS. Now, let me just say this because there may be some people watching this saying, oh, well, I don't have to worry about the IRS because they've been kind of quiet since COVID hit. Well, the IRS is coming back with a vengeance. It's the same thing with foreclosures. We are seeing so many more foreclosures now. I would say in the state where I practice, we are seeing more foreclosures in the next 30 days and probably the last 6 months, maybe longer than that. Things are accelerating, not by like 1 or 2%, but exponentially here. Same thing with the IRS. And you think about all the people because of the pandemic that from March 2020 through now, they may be just in a world of hurt. Maybe they owned a small business and they've gotten behind on their payroll taxes, all that sort of stuff. I mean, there is a coming tidal wave of IRS liens and levies. So let's look at this case because it'll give us a little bit of information. There's nothing particularly unusual about this or earth-shattering. It's just a recent example that I wanted to show you. So February 24 of this year, 2021. So we're talking about a collection due process. And look, the IRS loves acronyms here. So CDP. And so what happened was there was a notice of federal tax lien, NFTL. So that's where a lien is being placed on your property. Now, it happens automatically, but you do get a notice, and that's a public record. And so then you start getting advertisement letters, and you know that there's a huge problem. And so the taxpayer says, hey, in my CDP hearing, that's the collection due process, I was barred from sort of bringing back to life an offer in compromise, OIC, that had been rejected before the filing of that notice of federal tax lien. And just a little footnote here. So the Office of Appeals was renamed a couple years ago the Independent Office of Appeals. All right, so the respondent, which is the IRS, says, hey, the taxpayer failed to propose an offer in compromise, and the determination to uphold the notice of federal tax lien filing was proper, and the tax court agrees. So what happened? Taxpayer's car salesman, 2014, he made 250 grand, federal taxes of almost 100,000, and he withheld 33,000. So obviously he's coming up really short here, about 60 grand. And so the IRS says at some point, hey, we're assessing this tax on you, penalty, interest, all that sort of stuff. So he submits two offers in compromise. The first in 2016, and we're not told when the IRS assessed the tax liability, but considering it's for his 2014 taxes, right? So 2014 federal income tax. So that's really going to be filed, typically in 2015. And then there's a period of time to assess the tax. And so anyway, in 2016, he offers 9 grand. They said, nope, you can pay the whole amount. And he did not appeal that, which he had the right to do. But in January 2017, he says, I'll pay you a little bit less. Again, we'll call it about 9 grand. And he says, look, I've got these exceptional circumstances, and I have alcoholism, terminated from my work. I've had to liquidate my retirement. Now, let me say this. He never argues that he does not owe the money. Okay, so either he knows he owes the money or he just waited too long. In 99.9% of the time that people come to us about, hey, can you help me to deal with these IRS taxes? It's too late to challenge whether or not we really owe it. What we're doing at that point is using the rules of the IRS and understanding those rules and going to the IRS and saying, here's what we propose. And making sure that we have the best possible chance of being successful with that. So he submits what's called a Form 433A, and that's basically the form you have to submit when you're doing an offer and compromise. He says, my monthly income is $2,400 and my monthly expenses are $2,400, which if that was true, that would mean there's $0, assuming the monthly expenses are allowed. There's $0 per month. So all the IRS could do is look at his assets and say, can you sell your assets and use some of that money to pay us? And so he said, look, I want to settle for about $9,000. That's 2 of my cars, but not the one my daughter uses, and my motorcycle. He said, give me 2 years to pay it. Now, the COIC unit sent a letter rejecting the offer and compromise. Why? Because they said you've had the ability to fully pay your liability and you've offered less than your RCP. What's RCP? Again, they love acronym. Reasonable collection potential. And they said your gross monthly income is $4,900. So remember, he said it's $2,400. So no, it's actually double that. But they did say you have more monthly expenses, but that leaves $1,685 income per month that you could devote towards your $81,000 debt. And there's 110 months still remaining on the statutory collection period. So that's the time period to collect. Sometimes it's called the CSED, CSED. And they say, look, actually you could pay it off 53 months just using your disposable income. So that's just 53 times 1685 would be the 81. And taking into account interest and all that sort of stuff. So he appeals that. All right. Remember, I said he had the right to appeal the first time they rejected his offer and compromise. He chose not to, but he did appeal this one. He says, look, you've inflated my likely future earnings, and I don't have any disposable income. And the Office of Appeals sustained the rejection, saying the amount you're able to pay exceeds the amount of your offer. So the formatting got a little weird here, but now we have the CDP proceeding. So the IRS then the next month after the Office of Appeals sustains that rejection of his offer and compromise, then they issue the Notice of Federal Tax Lien Filing and your right to a hearing. And so he files this form 12153, which is a request for a collection due process or the equivalent hearing. If he had waited too long to file it, he gets the equivalent hearing, but it says he timely filed it. So he actually gets a collection due process hearing. And so he gets a settlement officer. And this will give you kind of the pattern of what typically happens here. And so the settlement officer schedules a telephone collection due process hearing and says, hey, give me some information. And this is so typical of almost every case decision we look at. He neither responded to the letter nor returned the requested financial information. Now, a lot of times what happens next is, and he didn't show up on the call. But this one, he did. So he did show up on the call. Now, he criticized that the unit that evaluates the offers and compromise, and he says, look, they messed up assessing my ability to pay over the remaining statutory period, which remember back here was 110 months? Let me back up. Yeah, 110 months. He says, you should not have done that. Instead, let me get back to this. What you should have done is looked at over 12 months. Okay? Well, did he have a good argument for that? We're not told. Settlement officer says, no, we acted properly. The first step in evaluating offer and compromise determine the basis of your likely future income, whether or not you can fully pay the liability before the time period has expired. And so they're saying, look, we've just got to look at this first step. How much are you likely to make? And then the settlement officer said, look, you can submit a new offer if you have a change in income, but if you submit the same offer, she's like, I'm just telling you, you're going to get the same result. But I will do a long-term installment agreement. Installment agreement typically is where you're paying the whole amount. And this would be $975. Okay, $975. If you remember, what the previous unit had said is, hey, you've got $1,685 that you can pay. Well, the settlement officer says, I'll do $975, and you can pay off the whole thing. And she gave him a deadline, July 30. He didn't respond. So August 2nd, called, tell me by the 6th, didn't respond. And so the officer closes the case. And then the Office of Appeals issues a notice of determination sustaining the filing of the NFTL. That's the Notice of Federal Tax Lien. So remember, the whole, quote, appeal was that the tax lien was going to be filed. Okay. And so in the middle of that, he says, yeah, but you guys should have considered my previous offer in compromise. And go back to the notice says, although you'd raised the issue of offering compromise, you didn't provide the documentation. You did not submit an offer in compromise, and you did not respond to. This is the pattern over and over and over. People do not respond. I'm not saying if you respond, you win. But what I'm saying is if you do not respond, you lose. If you respond, you have a chance of winning. Again, it's like understanding the rules of the game. It's sort of like this. We're in a football game. There's 10 seconds left. You're on your 30-yard line. Now, is it likely if your quarterback drops back and throws a bomb that it will be caught in the end zone or caught, and then the receiver will run into the end zone, score a touchdown, win the game? It's not likely, but you have a chance. Now, if you just snap the ball and fall down, well, you're guaranteed to lose. Okay? So at least fight, at least have a chance here. And so we're not going to cover all this. Summary judgment's just saying that there's no reason to have a full-blown trial. We can just summarily enter judgment. And so that's ultimately what the court does. Now, this is important, standard of review. So how does this tax court review that settlement officer's actions and the Office of Appeals actions? They say, well, when the underlying tax liability is not an issue, which, again, it almost never is an issue as a practical matter, we review the determination of the Office of Appeals for abuse of discretion. Well, what does that mean? We uphold the determination unless it's arbitrary, capricious, or without sound basis in fact or law. So it's not just that the tax court says, well, we would have done this different. No, it's got to be so bad. Okay, so here's a couple ways they look at it. Number one, did the settlement officer properly verify the requirements have been met? Number two, did the officer consider the issues that the taxpayer raised? Or did she just ignore them? And then number three, they balance the need for efficient collection of taxes with legitimate concern of taxpayer that the collection action be no more intrusive than necessary. And they say the officer did all three. So let's look at this. Verification. So they're saying even if the taxpayer doesn't raise this issue, we have the ability to look at it. And so the taxpayer did not challenge verification. And they say, you know what? It looks like a thorough review was done. Okay. Now, if it had been challenged, there would be more detail in this opinion. All right. So what about the second one? Issues raised. So the taxpayer says, well, my 2017 offer in compromise, that was an $8,900 one, was improperly rejected. And I should have been able to resubmit that collection alternative or negotiate a different amount. And they say, well, actually, you cannot raise that 2017 offer in compromise. Well, why is that? Because if it was raised at a previous hearing or an administrative proceeding or judicial proceeding and you participated meaningfully, then you cannot proceed. In other words, you can't raise it again. All right, that's what this paragraph is talking about. And they say, look, you appealed the rejection. And that went to the Office of Appeals. And we've held that the Office of Appeals constitutes an administrative proceeding. And then you participated in it. And remember, he was talking about, well, I don't agree with the monthly income, and I don't have this income, and you made a mistake. And they say, in short, he had an opportunity to explain his position to the Office of Appeals, and he took advantage of it. And so as a result, was prevented from raising that in this collection due process proceeding. It says, although the settlement officer addressed this matter, that does not revive it. It doesn't bring it back to life. Okay. And then on the balancing, he doesn't argue that they say it's conceded and the officer said, hey, I've balanced, we need efficient tax collection and we don't want this to be too intrusive. And so they uphold the decision. And they note he's free to submit to the IRS at any time a collection alternative. It could be an offer in compromise or an installment agreement supported by necessary financial information. All right, so why are we looking at this? One, it's a recent case. Number two, it's a good sort of short case to show you what these acronyms mean. Okay, what's a RDP, what's a OIC, all these different things. Okay, and then I also want you to take home this message that if you are dealing with the IRS, and this has application to court and other places, it's better to respond, even if you're ultimately not successful, than to do nothing, because then you're guaranteed to lose. Okay, at least you have a chance. At least you can say, you know what, I did respond to that settlement officer or that appeals officer. I did, whatever she asked me to do, I did it, and you know what, she ruled against me. But at least I tried. Okay, but when you don't respond, now this person participated in the phone hearing, and they're almost all phone hearings. So that's good, but we see a lot of people who don't. And look, this was a lot of money. Remember, the amount was, I think it was $81,000. If I can come back up here. Let's see here. Yeah, at the time, this is September 20, 2017, it's $81,000. I mean, that's a lot of money, okay? There are people that will spend way more time dealing with a $3,000 debt buyer lawsuit, which I do think you need to spend time on that. But this is 81 grand. That's a ton of money. You got to spend the time. You've got to do it right. You have to understand the rules. This is not the time or place to say, well, I'm just going to kind of wing it and surely I can figure it out. No, you need to know. You need to study this. Put the time into it. If you're going to do it on your own, you've got to be a qualified person. What I mean by that is, I'm not talking about a degree or anything like that. I'm saying you have to educate yourself so well that you are as qualified in terms of knowledge and understanding as a tax professional. Okay, that could be an EA, an enrolled agent, a CPA, certified public accountant, or a lawyer. And the other alternative is to hire a qualified person to say, give me good advice, okay? Because there are consequences to submitting these offers in compromise. They tend to stop the statute of limitations from running, okay? So all you're doing is giving the IRS more time. So if you file an offer in compromise that has no chance of winning, that's pretty foolish. If it has a very low chance of being accepted, well, then you have to decide, is it worth the risk? You really want to submit an offer in compromise when you are rock solid. I mean, you can show the numbers. Here's my income. Here are my expenses compared to the allowable expenses. So the IRS says, well, here's how much you can spend on housing or cars or this or that. And you want to make sure that you're within that range. And here's where some strategy can come in. Maybe the IRS will allow X number of dollars for a monthly car payment, lease, purchase, whatever. And right now you're driving a paid for car and you've got $400 a month in extra income. Well, the IRS is going to say, hey, that's $5,000 a year. You owe $30,000. Hey, 6 years, you can pay it off. But what if you buy a car and it's within the allowable amount that the IRS says? Well, now your income may be zero. Okay. Now, don't go do that without understanding the rules and understanding all the implications of this. My point is, sometimes we have to hurry up and slow down. Okay. What I mean by that is, yes, we want to file an offer in compromise or a partial pay installment, whatever it may be. But sometimes we got to say, you know what? I'm going to just wait a moment and I'm going to figure out what's the best strategy? Because better to take a little bit of time and then make the right move than quickly make a move that's the wrong move. It's like the old story of the guy. I think Stephen Covey tells us in his 7 Habits of Highly Effective People. You're in the woods and there's this guy sawing on a tree trying to cut it down, and he's got this really dull saw. And you're like, hey, why don't you take 30 minutes and sharpen your saw? He's like, 30 minutes? I don't have time to do that. I'm too busy sawing down this tree. Well, it'd go a lot faster if you saw. So sometimes we actually do better by slowing down and stopping and figuring out what's the right move, and then we can execute the move. And this is something we've talked about from day one of our law firm, which is you have to understand your rights. And then when you know your rights, then you know how to take the right action. If we're in a car and we're driving west and we say, it seems like I'm not getting to the Atlantic Ocean, I'm just going to drive faster. Guess what? We're never getting to the Atlantic Ocean if we're driving west. Okay? We got to go the right direction and then apply the fuel, apply the action. So, hope that this is helpful to you. If you have questions about this, just like all of our videos, just put a comment below. If it's a personal question, maybe a tax situation you're dealing with, just go to alabamaconsumer.com and you can fill out the contact form, and I'll be glad to get back with you and either see if I can help you or get you to somebody that can. Okay, guys, thanks for watching. You have a great day, and I'll talk to you tomorrow. Bye-bye.